Numbers on the up now, so I think we'll just kick off now, Andrew. Welcome along to this, a webinar on adapting for disability in the workplace, a practical guide to reasonable adjustments from CEF Patrons Mills Selig. Of course, it's a very important topic, so delighted to be joined by one of Mills Selig expert team today, Andrew Edwards. Andrew is an experienced employment solicitor and works with Mills Selig employment team. He regularly advises employers, large and small, on a whole spectrum of employment work, from day-to-day HR problems to the big picture issues. So thanks, Andrew, for joining us. Just to say, at the end, there'll be time for questions. So if you feel free to pop one in the chat, and as I say, we'll come to those in the end. But happy to hand over to yourself, Andrew, to get started there.
Thank you, Vincent, and hi, everybody. I'm just going to get my excuses out early. One, I'm doing my own slides, so if I'm looking down, then I'm just figuring out how to knock them on, not the most tech savvy person. And two, maybe fittingly for this conference or this talk, we are having construction work done in the building, and so if there are any loud noises, it's probably just that. If you can't hear, let Vincent know, and he'll let me know. And we can maybe pause it for a second, but hopefully there'll be no issues. So I'll get started. It is something that comes up a lot, and it's something that we're often advising on, and yet probably employers don't always necessarily know what it means. So let me run through. Just start then. A little bit about Mills Selig. We are an independent law firm based in city centre Belfast, right near all the cafes and the shops. We regularly work on corporate and commercial deals, advising a whole range of clients, but we do a lot of work for employers. We have, as you can see from that, we have a 360 approach, which means even though the main part of the deal might be construction or corporate, we do all the employment or the property or all the rest of it alongside. So it's just a little bit about Mills Selig, and I'll get started properly now. Thanks. Yep, sorry. Okay, so the first thing is then just to talk about what disability is in an employment law context. People's perception of what disability is may well differ to what the law, employment law, says disability is. So there are 4 components, and that is has to be either a physical or a mental impairment that has a substantial adverse effect, and that adverse effect is long-term, and that has an impact on a person's ordinary ability to carry out normal day-to-day activities. So I'll run through each of those in turn then. The first one then, physical and mental impairment. Physical impairment, fairly obvious, well, mostly obvious probably. I mean, I guess some disabilities are hidden, but it often is quite apparent. And mental impairment then is more difficult to establish, particularly with the whole range of mental health issues that are prevalent at the moment. Other aspects of mental health or mental impairments, and it is a case-by-case basis, and that's what you'll see as we go through this talk, is that things like Asperger's, ADHD, autism, chronic fatigue, ME, they have all been held to be mental impairments and or physical impairments. So it's just worth bearing in mind. Another thing which I will kind of come back to, but is there is a distinction, and the courts, which is where we get a lot of the law from, does make a distinction between somebody who has anxiety or depression as a result of a clinical mental health condition, like clinical depression, is different to somebody who, has work stresses or suffers a bereavement or some other adverse life effect. So stress and depression, whilst used interchangeably these days, often there is a difference. And when you have cases where an employee is reporting stress, it's important that you come back to this 4-stage test to figure out whether or not their condition or how they're feeling actually matches the definition and satisfy each aspect of that definition. Just on the impairment piece then, there are a few things to make you aware of. Some disabilities are they're called deemed disabilities, which is almost like an automatic disability. So from the point of diagnosis, that person is disabled and they always will be disabled. You don't have to go through the 4-stage test. That includes conditions like HIV, cancer, MS, blindness, severe disfiguration. On the flip side of that, there are specifically excluded conditions like addiction to alcohol or drugs, which don't amount to a disability at law. The next thing then is just, in the slides it's at point 4, but it helps to kind of just discuss it now, is the effect it will have on normal day-to-day activities. So that is just your average run-of-the-mill day-to-day activities like making dinner, walking to the shop, socializing, going to work, taking public transport. It's not anything specialized like playing sport to a high level or playing a musical instrument. And then there are, I think this is the right way. Yeah, so I'm just in terms of normal day-to-day activities, the list there then contains a range of different things which are considered whenever we think of normal day-to-day activities. I'll not read through them on the screen, but you can see them, what they are there. Then just the impairment that has an impact on normal to day-to-day activities has to be a substantial adverse effect on those day-to-day activities. Substantial has been held to mean more than minor or trivial, which I guess isn't really that helpful, but something that's maybe more helpful is to think about what can the employee not do because of this impairment. That should be your focus, rather than thinking what can they still do despite having the impairment. So what can they not do because of their impairment? Okay, and that'll become more keen in your eyes whenever we're actually talking about the reasonable adjustments. Something will be deemed to have an adverse effect if the substantial effect, even if at the time there is no substantial effect, but the substantial adverse effect is likely to recur, or if the condition is progressive. And then the last part of the definition, which I'll just flick back to, the long-term aspect of it, is something that lasts for 12 months, is likely to last for at least 12 months if at the time the impairment happens or comes to light hasn't yet lasted for 12 months, or if it's likely to last for the rest of someone's life. So that's that. Okay, so reasonable adjustments then. Just before we look at the factors, I just want to talk to you about when this duty to make a reasonable adjustment arises. Whilst it applies to employees, it also applies to job applicants, and I'll come to that in a second. Okay, so the law is a little bit wordy, but I'll explain it to you. So the duty to make reasonable adjustments will arise if an employer has a practice or a policy which puts a disabled person at a substantial disadvantage compared to a non-disabled person, or, for example, if there is a physical aspect of the employer's premises or where they have to go to work, which means that a disabled person can't access the building, for example, steps rather than a ramp or whatever. In this situation, the onus is on the employer to take such steps as is reasonable to avoid or to remove that disadvantage that disabled person will suffer. A lot of times employers or businesses will come to us and say, well, I didn't know that person was disabled. That's not necessarily a defense. Okay, so the test is, was the employer aware of the fact that this person was disabled and was placed at a substantial disadvantage in relation to a policy or access to premises or whatever, or the employer to have known? Now, that's not saying that you have to know in every circumstance, but for example, if someone is off work, increased time rather compared to somebody else in the office, or they illustrate certain behaviors which don't necessarily make sense, good practice and to protect yourself as an employer, think, okay, what is the reason for that? Is someone having extended absences because they have repeated coughs and colds, or could it be due to an underlying condition which may or may not amount to a disability? So just because you don't know, and just because an employee specifically doesn't raise it, and you'll certainly find that with certain conditions, an employee may be embarrassed to raise it, that you can still, as an employer, be deemed to have known about it if a tribunal decides that it was reasonable that you should have known. I mentioned job applicants there a little minute ago, and just to point out that that's not for you to make sure that all your processes for job applicants are completely kind of adjusted to take account if a disabled person might apply, you know, if that's some kind of something that's completely uncertain. But if there is an interested disabled person, then you have to consider those adjustments. And an interested disabled person is either someone who's specifically notified you of their intention to apply, or they've notified you that they may apply. So looking at what is a reasonable adjustment, and I'm going to come on to specific types of adjustment that you can consider. A reasonable adjustment can include the factors that are on the screen. So first one, and it's one of the most important, is the effectiveness of the step in preventing the disadvantage. So the whole point and the law behind reasonable adjustments is, if the reasonable adjustment is in place, remove the disadvantage that the disabled employee is suffering with the intention of keeping them in work. If there is an adjustment put forward by the employee or by occupational health that will have no impact on keeping that disabled person in work, then it'll often be considered to not be reasonable. You'll see the other aspects on the screen that you have to consider. So how practical is it to make the adjustment, the financial and cost required, the extent of any disruption, the extent of the business's financial resources, the availability of other financial help. You can often get help from charities or access to work kind of initiatives, and what other adjustments have been made for other staff, and the impact that introducing a certain measure would have on other members of your staff. Just a couple of practical tips then in terms of reasonable adjustments, and these are really taken from our own experience when we're advising clients. One of the most common misconceptions is cost, and you'll see on the screen where it said the cost required and the extent of disruption. Just because something costs money doesn't mean, or would not be cost effective to implement, doesn't mean that you shouldn't do it. Particularly large employers, given their financial resources, a tribunal, if it got that far, would expect there to have been adjustments made that may not be strictly cost effective. You have to remember that the point of this law is to remove the barriers or the perceived barriers that disabled people have to get them into work, and to provide a more diverse workforce with people from all different backgrounds and abilities. The other thing then is the fact that as you all know, with any condition, it's a case you should take on a case-by-case basis. You might have two employees who are diagnosed with the same condition or illness, and yet employee to employee, the impact of that condition on their ability to work or their ability to do normal day-to-day activities might vary widely. Also, with a progressive condition, it might initially start as something that doesn't really have much impact on their ability to do their work, but maybe something that gets worse, or there are other conditions that are bad for a while, and then they kind of go into remission, and then the changes come back and really affect the employees. So it's really important just to take something on a case-by-case basis and to regularly monitor that. Certainly we see some line managers are keen to do a quick fix, sort the problem once and for all, move on and consider it done. And for certain conditions that might work, for certain employees that may work, but it's important to keep the situation under review, to check in with the employee, to ask them how the adjustment is helping them, whether any further adjustments need to be made, and and just to kind of keep it in the back of your mind that just because you've made the adjustment once, that's not necessarily the end of it. The other thing, which is really important and is often a cause of concern and frustration, and often that actually leads to tribunals, is a lack of process or a lack of visibility from the employee's point of view. So an employee comes to you and explains their condition, and in your head, or after speaking with us, you're thinking, yeah, they are disabled, but we don't have enough information about them. So we'll speak to their GP or the consultant who is looking after them, or we'd often refer or encourage employers to refer employees to occupational health, because they can specialize in have specialist knowledge in terms of what exactly can be done to facilitate a return to work, or to facilitate adjustments that will allow and remove that barrier. So employees often feel that they go through and they see occupational health, and the employer then considers whether or not they can make the adjustment, and that's important, because it's not an automatic right. If an employee suggests an adjustment, or occupational health suggests an adjustment, it doesn't mean that the employer has to implement that adjustment, but you do need to consider it. And if you're not going to implement that particular adjustment, it's important that you look for alternatives, and that you explain that to the employee, just from a point of managing employee relations and morale. Yeah, and then, as I said, have a follow-up meeting, check in with the employee, see how they're getting on, and really just make sure that they are in the loop and know what you're doing. And I say, it really, if you can't do that specific adjustment, that's okay, but take a note of it, because it's often something that will come up later down the line, and employees might often be aggrieved by it. The other thing is, when you are making a note of it, remember that under the GDPR, those favourite 4 initials that we all have, there are certain types of data, personal data, that are special category data, and an employee's health records or illness or condition certainly falls into that category. So if you are taking notes, make sure you store them safely and securely in accordance with your data retention guidelines. The other thing then is, we often get employees who are uncooperative. Now, it's not a defence in a tribunal to say, well, it was really hard to get that information, or they resisted or didn't allow me to access their medical notes. That in and of itself is not sufficient. You can refer someone to occupational health. You can ask them to speak to the GP, or you can speak to, if you're aware of what the condition is, but you don't have the details, like for example, someone who's partially sighted, for example, you could speak to the RNIB and ask them, what typically do people who suffer from partial sightedness have impact in their work, and what can we do to kind of remove those barriers. So uncooperative employees, never easy, but just because they're uncooperative or not really playing ball doesn't mean that your duty to consider reasonable adjustments is removed. And then the last thing, and we've already touched on it, about confidentiality, is sometimes the employee won't want their colleagues, or maybe even the other managers in the business, to know of their condition, which may be difficult to disguise, because, or not say disguise, but to kind of keep confidential apart, because one of the adjustments might be to reduce their workload, and if other employees were to find that out, they may have questions. So it's best to kind of have a conversation with the employee and agree an agreed approach in terms of how and what you can say to other employees and what you can say to managers. Certainly from a GDPR point of view, again, special category data, whilst their line manager may need to know a certain amount of information about the medical condition, they don't necessarily, and they shouldn't, see medical records and occupational health all the details. They should just know a broad amount of what is the condition, how it affects the individual, what adjustments the decision has taken to what adjustments the employer has taken to make those kind of interventions. I think the next slide. Yeah, so on the screen you've got a number of different reasonable adjustments. I'll let you read through them as I kind of pick out some things that just to kind of put a bit of flesh on the bones. So the first one then, making adjustments to premises, that might be about widening a doorway, putting in ramps, enabling them to work their workstation to be near a toilet, for example, if they have like an irritable bowel condition, for example, or that the area they work in is hot or cold or well ventilated, depending on what the condition is, or that they can work from home, either if it's kind of a progressive condition that's up and down, work from home whenever they have a flare up, or work from home permanently. There is a real kind of range, and it is really, whilst we're going to talk about specific adjustments that you can do, it really comes down to what between you the employer, them the employee, and any third party advice from occupational health or whoever else, what everybody says to what people say would create an adjustment that people would be able to have, which would then lead to that disadvantage or that barrier being removed. Other things, for example, allocating duties to a different person. Well, it may well be that you can transfer some of the duties if someone has, I don't know, vertigo from a medical condition, and part of their job is going up on roofs and things. Then you could transfer that to a different employee. Or if somebody has a progressive condition that gets gradually worse and they're no longer able to do the job that they were employed to do, you should consider if they can do a suitable alternative role, to avoid them having to not work at all. Another example is allowing someone who's disabled to have time off, paid time off during work for either rehabilitation or treatments, or it may be that you allow, I don't know, one absence every 6 months for health appointments or whatever, and that you consider having additional number of appointments for people who have to attend these various physicians for disability related absences or appointments. If, as many of you do, work in a manual handling industry, it's maybe allowing somebody to have more time to complete their tasks. Connected to that, then people may be paid for their completion of certain tasks, pay per output, and someone who has, I don't know, rheumatoid arthritis, for example, will naturally not be able to do as much as somebody who is not disabled, doesn't have rheumatoid arthritis, and will have to take regular breaks. So you can consider, and it has been held, a reasonable adjustment would be in the time that those individuals have to take a break, that they are paid a certain amount, like a fixed rate for the time off during breaks, so that as a result of them having rheumatoid arthritis, they're not earning necessarily less than somebody else would, or less than they could if they didn't have rheumatoid arthritis. And then there's other options on the screen there. Recruitment, then, it's a big one, and again, one that we have plenty of questions about often, and it's all about what can we do and what questions can we ask. So you have to strike a balance between asking somebody information which is necessary for them to do the job, for example, in intrinsic nature, like if they have to climb scaffolding, and or if there's an adjustment that may be required to the format of the application form. So people with Asperger's and other kind of neurodiversity, as it's known these days, autism and things, they may often struggle with a face-to-face interview, so you could consider allowing them to answer questions in writing. It's really about striking the right balance between asking the questions that are really necessary, and be careful not to kind of create the impression that you're going to discriminate against someone, or depending on how the recruitment process goes, that you actually treat the information that they have given, I say, unless it's for something that's intrinsically important and key to the actual job being done, that you treat that information and don't give them their job, which would be directly discriminatory. The general rule of thumb is, unless it is something that is specific for either the job itself or the recruitment process, that you leave those questions till later on in the application process. If you're asking any questions before making somebody an offer, say they have to be absolutely necessary, and it is really the exception rather than the norm. The other thing, and this is more just a practical point, if you are collecting information from somebody as part of the recruitment process about their health, it's incredibly important that you keep that information separate to the scoring that you do for the actual role. And that doesn't play a part in the decision whether or not that person gets the job. It's vitally important that that is kept apart from the actual recruitment process itself. And then the other thing is that disabled candidates, if they don't get the job, again, we really recommend that you keep a note of exactly why they didn't get that role, so that you can show that if they were disabled or would pass that 4-stage test, which is a mental physical impairment, which has a substantial and long-term adverse effect on their ability to do normal day-to-day activities, that you have a note of that, of why they didn't get the job, and that also that you, and this is often missed, that you considered what reasonable adjustments you could make either in the process or once they started a job that would remove those barriers to them getting work. It's so important that you're able to show that and that you have a note of that. Otherwise, absent a kind of contemporaneous written note, it'll rely on verbal evidence at tribunal, and you're in a much weaker position. And it's one that comes up time and time again, so I really can't impress the importance of having that note and considering whether or not in advance of them joining there would have been a reasonable adjustment that could have suited them. If you do identify a reasonable adjustment that could potentially help somebody, then it's important, and you identify that pre-employment, it's important that you have that for day one rather than 2 months down the line or something. These adjustments have to be made in advance of the person starting their employment. Next slide then. Long-term sickness then is something that I think it affects every employer, and it's one again that we often apply the test of. Is that person disabled? Just because they have a long-term sickness doesn't necessarily mean they are disabled. Long-term adverse effect is one of the aspects of that 4-stage test, but they have to still have a physical and mental impairment. It has to have a substantial adverse effect on day-to-day activities. So you really have to kind of think through that test and think of whether or not a person is disabled. Of course, if they have one of those deemed disabilities I was talking about earlier, then they automatically will be treated as having a disability. So it really does just depend. Then if someone is on long-term sickness, we often find that most employers have a long-term sickness absence policy, which says something along the lines of you are permitted to have up to 4 absences or 20 days 20 days of absence, no matter how many times it is, in a 6-month or a 12-month period, and that if you have more than that, if you exceed those triggers, that you'll be invited to a disciplinary meeting or a poor attendance meeting. Now, if someone has a disability, then naturally, or maybe not naturally, but quite often, that will lead to them having more time off work. And then we have to think of what would be a reasonable adjustment here. So one approach is you discount all disability-related absences. Or sometimes it might be difficult because it might be difficult to establish whether the reason for the absence was because of disability or was because of something else. And maybe the individual hasn't been maybe forthcoming and telling you what exactly that was. Or it could be, right, if someone gets a first warning after a certain time, that you don't give that initial warning. But good news, if you can call it that, the tribunals aren't necessarily saying that you have to have all, you have to discount all absences, just that you can discount some absences. So it really is, and throughout this, it really is the case. It's a fact-specific thing. Sometimes you discount, you can, and sometimes I recommend to discount all, and sometimes it's just to modify it. No employer is expected to live with an employee that can never work. That's absolutely not the case. Sometimes employment lawyers would say, oh no, if someone's off for disability-related absence, they have to be employed forever. That's not surely true. And it's all about taking the adjustments at the time, considering whether that adjustment would enable the employee to return to work. If the employee is never going to return to work or is likely to never return to work, often recommend at that stage to get medical evidence. But if you do get medical evidence, and medical evidence says they've got no reasonable prospect of returning to work within a reasonable time frame, often 6 months, then 6 or 12 months, then you still can move to dismissal or ill health retirement, dismissal on the grounds of capability. The other thing then, and it often comes up, is the employee will have a disciplinary or a grievance procedure, and if someone is disabled, then we should consider what adjustments we can make to that. So depending on the disability, one adjustment could be to allow them to have the meeting off-site, or most of you, I'm sure, will know that the standard accompaniment you can have for a meeting is either a colleague or a trade union representative at a disciplinary or grievance meeting. It may be appropriate instead to have to allow a family member to attend, or for the process to be conducted in writing. So it really does depend on the nature of the disability, the nature of the individual, and what reasonable adjustments you can offer. But there are certainly some things that you can consider. And then I think just before I get to the Q&A, then just a few key lessons that I would like to kind of bring to your attention, just to kind of recap and reiterate. There are so many reasonable adjustments out there. There isn't a prescriptive list. I say it's all about what would this do, or how would this help the employee? Would it help to remove the disadvantages they have because they're disabled? If it does, then you should consider it. If the option put forward either by the employee or by occupational health isn't suitable, it's okay to say no, but you need to look at solutions, you need to look at alternatives. The other thing is, what is reasonable may develop over time, so it's important that you take a regular kind of review with the employee and check in with them. Then I guess the other thing is that whilst you are reviewing somebody, you want them to make sure that they feel supported and that you are doing everything as their employer to help them. But at the same time, you have to think of not to harass them or to put them, to kind of put them in a position where they feel that they're always being asked. So it's about getting that balance, and you will know better than anybody else how they will respond to being checked up on, and what exactly would work best for them. And then the other thing, which is the last thing, is just because you've had someone in the past who has had MS or cancer or rheumatoid arthritis, for example, just because you've had one employee have that, the adjustments you made for that employee may not be suitable for the next. And so it's important about taking a case-by-case tailored approach, discussing with the employee what adjustments they would have, and if you feel necessary to refer to occupational health and get their input. Ultimately, they're the experts. They're the ones who deal with these cases day in, day out, and who can suggest adjustments that would potentially work for you in the business. I have a list here of other just reasonable adjustments that we maybe haven't covered, and I'll just read them from my list here. And, changing working hours to avoid rush hour travel, flexible or reduced working hours or more breaks, providing quiet area for a rest, allocating them a parking space nearer to the nearer to the front door, also in the type of lighting at the workstation, giving someone, this is particularly people who are neurodiverse, giving someone advance notice of any changes or disruption to their day, having a phased return where somebody has a particularly physically debilitating condition, and some mental conditions too, allowing unlimited toilet breaks if somebody has irritable bowel syndrome, for example, making the workplace safe in case someone has a seizure. So maybe removing any kind of I don't know, but furniture that doesn't need to be placed near to someone, and as much as that is reasonably possible. Using handrails as and where appropriate around the office. Recording meetings to allow the employee to work through it at their own time, rather than having to take it all in as it happens. Having a timeout policy, particularly if symptoms worsen, so an employee can take a rest and feel comfortable to take that rest. Perhaps training colleagues about mental health and how that affects employees, so that employees can informally help people in the workplace to support them. And another one, maybe in certain circumstances, excusing employees from attending what would otherwise be a mandatory work function. And again, just regular reviews with occupational health can help you keep on top of what that employee is going through. And sometimes, if you don't want to approach them directly because you feel that they would be awkward about it, or would feel that the employer was being unnecessarily intrusive, having that conversation just really allows, with occupational health, really allows them to feel that they're cared for, and allows you to ensure that you're doing everything you can. That's it really for me for now. Bit of a whistle-stop tour, so reasonable adjustments, and I'll take any questions. Thank you.
Fantastic. Thank you, Andrew. Some really helpful points there, indeed. With one or two questions. Anyone else, feel free to pop a question in the chat there if there's any more, but one or two questions coming through. So one is substance misuse. What is the legal position on determining disability if an individual has or develops an impairment such as depression that was likely caused by alcohol abuse?
Yeah, thanks, Vincent. It's a good question. Yeah, people often think that if someone has, and look, sometimes it can be difficult to prove, but if someone has a secondary condition that we believe derives from an excluded condition like alcohol abuse or drug misuse, that anything that follows cannot be a disability, and that's not true. If someone develops depression, likely caused in their case by alcohol misuse, that can still amount to a disability. So, well, the alcohol misuse or the drug misuse or addiction does not amount to a disability. A secondary factor which follows from that, I don't know, maybe diabetes or depression or any other condition, it can still amount to disability if it satisfies the test that we ran through at the beginning, which was a physical and mental impairment that has a substantial adverse effect and a long-term effect on someone's ability to do a normal day-to-day activity.
Okay, thanks, Andrew. And just one more question here. In a scenario where an employee with long-term absence is dismissed under a sickness policy with no medical evidence that supported they were disabled at the time, after dismissal, the employee is granted disabled status. Is their employer likely to face a tribunal despite the fact the disability was undiagnosed at the time?
Yeah, and maybe the person who asked the question will have to answer my question first before I can answer it. But you say they were undiagnosed. Did they have symptoms which which suggested that they suffered from a physical and mental impairment, because there is a difference between an employee that we're not aware, and to all intents and purposes, there was no indication to the employer that there was any impact on their ability to do their work. They regularly attended work. They didn't miss appointment. Didn't miss work. Had no poor attendance. And the employer couldn't reasonably been held to have known that they had any form of disability, versus an employee that disables loads of symptoms and yet it just wasn't diagnosed formally medically. There is a difference there. So, and I'm happy to pick up offline with whoever's asked that question and talk them through specifically. But say just because it's not formally diagnosed doesn't necessarily mean that it will not amount to a disability if an employee can show that it satisfied that test. And the other thing to say is, when a tribunal looks at it, they will look at their whether they were disabled at the relevant time. So whether they were disabled at the time you were going through that long-term absence process. If they became disabled after the conclusion of the process and had no impact on their ability during the process, then on a straightforward looking at that, they wouldn't be disabled. However, if they had the symptoms, they just didn't have the diagnosis, then likely yes, they would be disabled. And then whether or not they bring the claim is entirely up to them. But certainly I would say there would be a possibility. But whoever asked that question, I'm happy to pick up with offline, because my answer depends on the question I asked.
Okay, thank you. Super. That was great. Really good insights there. Thank you, Andrew, again, and thank you all for attending. Just say thanks again to CEF Patrons Mills Selig for their guidance in this. So if that's everything, I'll draw the webinar to a close there. And thanks again for attending. All the best. Bye-bye.
Thank you. Cheers.